Secondary education, Khatoniar. MJ Khatoniar. And R6 is whom? R6, UGC is the party, Mr. Bora?
It was made a party later.
Is it a party?
Yes.
A Chamwa, UGC. This has not present. Yes. Is there any interim order?
No.
I beg to mention for item number 10, Your Lordship.
10.
Unavailable of P. Rahman, Your Lordship. So the matter may be come up vacation, Your Lordship. Item number 10. Motion.
Who is not present? P. Rahman.
P. Rahman, yes, Lord. I am assistant.
Very correct. On the prayer made on behalf of the petitioner, after the vacation. Yes.
Master.
I beg to mention item number 13, my lord.
1-3.
1-3, my lord.
Yes.
This matter may be taken up after the
13 has been mentioned.
Yes, my lord.
13 has already been mentioned.
13 on 3.
It has been mentioned.
You already mentioned.
Huh? One? Pune Kodle hale. Which that is not mentioned. 31. 31 to police there.
1-3.
Dismiss for default police there.
1-3, my lord. 13.
Dismiss for default letter. Dismiss for non. Dismiss at a non-prosecution gun process. 12 was released. Okay, 12. Okay, 13. What do you want? What is your prayer?
Just after a vacation, my lord.
Okay, and petitioner on behalf of the petitioners our vacation. Okay.
My lord.
Yes.
I beg to mention item number 29 and 30, my lord. I have taken consent from the petitioner.
You
I have to file affidavit, my lord, but I could not file affidavit, my lord. Immediately after vacation, I filed it.
Your chronicle for the Dimasa
Also.
on the prayer made by Sri A. Chronicle, learned standing council. Standing council, NCHAC, should be NCHAC. NCHAC, matter stand adjourned to be listed after the vacation to enable him to file the affidavit in opposition. Both matters.
Both matter.
Is there any interim order?
No, ma'am.
Yeah.
Deeply over.
Other side is informed?
Lordship, I beg to mention item number 47, Lordship.
Yes.
Lordship,
Supplementary list.
daily
Oh,
list, Lordship.
last matter.
Yes, sir.
Yes. What is,
Lordship, the matter may be adjourned for the day, Lordship. My senior is not well, Lordship.
who is your senior?
SKN Muhammad, Lordship.
Okay. It is submitted that Sri Sheikh Nur Muhammad is unwell. List after the vacation. Karapuri, no? Summer vacation. Vacation, summer vacation.
With the consent of other side, I beg to mention item number 39 and 40.
39 and 40.
Kindly adjourn for the day and expect come after vacation.
Here for the petitioner.
Petitioner.
What is your name?
SS Islam on behalf of MJ Qadir.
Okay. You have to tie your button. Why haven't you tied your button? You're a young lawyer. Come like this. On behalf of petitioner to be listed after the vacation. 39 and 40.
Yes, Lordship.
Yes.
May it please, Your Lordship, I beg to mention item 46 with the consent of the other side.
Yes.
May it be listed after vacation, Lordship.
Taking the consent of the other side.
Yes, yes.
NCT, BTC,
No,
all.
BTC only, and not
NCT is there.
I.
Prime.
Prime.
IA for what?
I'll inform.
IA for?
Actually, what has happened, there was an interim order of this court. By violating the interim order, they have already made appointments. Now that they have just filed a reply, Lordship, I have spoke to my client since they are only 23. So whether it will suffice their case or not, Lordship, we are Lordship listed.
NCT, Mr. Is what? Alam is there. Alam. You will adjourn it, but inform him.
We will inform. Lordship.
Inform him.
Sorry.
Will not pass orders until you inform. You inform. We'll pass orders. We'll adjourn it. Don't worry. But not now.
May I please, Your Lordship,
Okay.
like to mention item number 32.
Yes.
With the consent of the other side, kindly please fix matter after vacation.
Here for the petitioner.
Yes, Lordship.
The other side's consent taken.
Yes, Lordship.
Petitioner, after the vacation, summer vacation.
Item 30.
32.
Maybe, Lordship. Okay, I make mention item number 4, Lordship, daily list. Even the Lordship may be listed after vacation, Lordship.
The motion matter,
Permission, Lordship, petitioner want to engage senior counsel, Lordship.
your name,
NH Lordship, Lordship.
Sri Anish Laskar, learned counsel for the petitioner submits that the learned counsel for the petitioner submits that the petitioner would like to engage the senior counsel for which some time may be granted for the list after the summer vacation. Yes. Madam, you're for SSA.
SSC.
P does understanding council SSA. An elementary? PK Bora, elementary present.
May it please, your lords. I beg to mention item number 18 from today's list, my lord.
Yes.
My lord, in this matter, my lord, we are unable to contact our client, my lord.
Hmm.
For getting some instruction as this honorable court has directed on the earlier occasions.
16 matter.
Yes, my lord. So, my lord, 1 week time may be given, my lord. So we can contact our client, my lord.
16 matter, not like this. Will not pass
Maybe,
an
my
order.
lord, but this court sought some instruction from our.
Yes, if you are unable to bring the instruction, we'll proceed with the matter. 16 matter in 2023, you are seeking time.
1 week time, my
1 week, the vacations will come. 4 weeks it will go.
any date after vacation, my lord. Kindly, my lord.
What is your name?
Yes, Upadhyay.
S. Upadhyay, letter counsel for the petitioner submits that some time may be granted to obtain instructions. Other side informed,
Yes, my lord. I have informed the junior.
R9, respondent number 9,
Respondent number 9 has not been informed.
you have to inform them. Don't make a mention without informing. All the concepts you have to inform, not now. That's it.
Okay,
Yes.
my lord. I'm highly obliged.
May I please, your lord. My lord, in this matter, there is only one small point to be decided, and that is in fact,
Covered already. Covered already.
no, it's already decided when the motion, when the notice of motion was issued. If your lordship looks at the page, paragraph 18 of that order, my lord.
Yes.
Only thing,
10 to order.
yes, my lord. Only thing, the last examination, what it is. So court considered the last examination would be 2017, February to March, because
Correct.
after that only the act has come. So I'm covered because I've got more than 10 students, 13. What they have done, they have considered 2016, and that is the reason my provincialization was not done. That is the only case, my lord.
Yes, what are your instructions? Who is appearing
And
for this elementary education?
Probably secondary, my lord. Secondary, no.
Which department?
secondary.
Secondary, who is there?
After some time, my lord, and just is coming.
Okay, after, wait for a while. But ask him to come. These are top of the list matters. Why 23 matter is top of the list? Is a 23 matter? Top of the list means all matters. Okay,
No.
we'll have it. Let him come.
I had no hand in it, my lord.
We are asking. We are not saying that it's been listed at your instance.
But still I can say why it is. In the month of March, it was supposed to be listed for the next order. Somehow it was not listed.
Okay.
After that,
Even then, we have matters of 16, 17, which,
no, actually,
which requires to be on the top of the list. Okay, we'll take it up. Don't worry. Yes, next. A. Rajkua, R.P. Hazarika, 21 matter. I ऐसे नहीं है लोग
On last occasion, they have submitted, then I has been filed before this honorable court.
Probably this matter may impact us, my kindly see the prayer.
Was there any interim order?
My lord. In the record, my lord, case record, I have not found, my lord. There are only two orders, my lord. On the first occasion, they have taken time to implement the FSA.
None appears for the petitioner on call. Para. The petitioners, who are 11 in numbers, had challenged an advertisement
I felt to the complete.
which required advertisement as per which an examination was scheduled to be held on 28 to 2021 in connection with the teacher's eligibility test. Though this matter was filed on 18 to 2021 and the last date and the scheduled date was 28 to 2021, this matter is pending since then at the motion stage without there being any interim order. It also appears that an IA was filed for implement of the mission director SSA, which however is lying defective, as would reflect from the office note dated 18/5/2023. Though it prior appears that there is no life for the election and the matter has become a practice, in absence of the learned counsel for the respondent, this court would not like to pass any orders on merits. However, the matter is dismissed for non-execution. PPK Bora, Learned Standing Council, elementary education is present. The state is also a party, madam?
No, my lord.
It's not
Member
there.
secretary, employer committee.
The district member.
Legal and resolution.
PK Bora. Yes, next.
Obliged.
Yes.
Maybe this matter is impactful now.
Three, BP Bora, Learned Counsel for the petitioners, submits that by flux of time, the matter has become infructuous. Also heard, three MS, Leaders Burman, the Learned State Council, three PK Bora, Learned Standing Council Education, three I Alam, Learned Standing Council NCTE, MS RB Bora,
Yes.
Standing Council BTC, three R Dhar, Standing Council WPT and BC. Anyone else? No one else. You could have got implemented other respondents also. Repetition accordingly stands dismissed as infractuous.
I have taken the consent morning for the morning.
No, we have recorded. You are not mentioning this as matter has come on its turn. No problem. Yes. 5, who's there?
Latif. Latif, instructions were sought from the current by the last order, Latif.
Yes,
There is another order of Latif.
but this is at the motion stage.
Latif, but the honorable court wanted to sort it out urgently, Latif, because there was a lot of delay, Latif. The person has been hanging, Latif, although selected.
Here we have received the instruction, my lord. In the dice data for 2011-12, his name is not appeared, my lord.
That I have
That is why-
explained, Latif.
That is why, my lord.
You do one thing, we'll not have this 21 matter at the motion stage. We'll issue notice
Lots
for
of-
formal
lots
and
of-
try to dispose it at the admission stage.
Latif,
In the meantime, you file your affidavit.
My lord.
Latif.
Heard MS, heard 3, M. Bhagapati, learned counsel for the one petitioner, Mr. Bhagapati,
Latif, only one.
for the petitioner who has approached this court for a direction for provincialization of his service as an assistant teacher of Chirakwa Kandapara ME Madrasa Dhubri. Free PK Bora, learned standing council. Elementary Education Department submits that instructions have been received as per which there is an issue with the DIAS code. Full stop.
Latif,
Let
scrutiny, there was a scrutiny, Latif.
his submission,
Latif.
let DIAS code. The para issue notice of motion returnable on 21st of July, not on 21st, it's on 28th of July, 28/7.
Latif.
Free PK Bora, learned standing council. Elementary Education Department accepts notice on behalf of respondent numbers
1, 2,
1, 2,
5, and 6, my lord.
5, and 6.
My lord.
Full stop. MSD does Burma State Council for 3
and 4.
and 4. Let extra copies of the writ petition be served upon the learned council for the respondent by tomorrow.
Yes, he can take for 6 also, I think, Latif.
6 already taken. 6 years taken. Theft for service of respondent numbers. Service upon respondent number 7 and 8 be taken by registered post daily by tomorrow. By the next date, Sri Bora may file the necessary affidavit in opposition based on the instructions said to have been received by him.
Marshal, obliged.
May please, Your Lord. My lord, in this case, my lord, I have filed the additional affidavit in one, my lord, on 23/6, my lord. That is not on record, my lord.
What is the additional affidavit about?
My lord, regarding the person whose service has been provincialized, my lord, whether is in which subjects he is.
Copy served upon you.
My lord, I'm right now little bit handicapped, my lord, record is not. with
Okay,
me.
we'll have it immediately after the vacation. Let the affidavit be
My lord,
connected with the record.
my lord.
Sri R. Sharma, learned counsel for the petitioner. No, but this is in the motion stage.
My lord,
Will issue notice of motion. Heard, don't say. Heard Sri R. Sharma, learned counsel for the petitioner who has approached this court with regard to with the grievance that her service, with the grievance that she has not been given the benefit of provincialization of her service. Full stop. Sri Sharma, the learned counsel further submit that an additional affidavit has been filed on
23/6.
23/6/2023, which however has not been tagged with the record. Full stop. Para. Issue notice of motion returnable by 4 weeks. Sri PK Bora, learned standing counsel, Elementary Education Department, accept notice on behalf of respondent numbers 1, 2, 3,
4 and 6.
4, and 6. Full stop. বা semicolon দিব, MSD Das Bormon, London State Council accepts notice on behalf of respondent number 7. That extra copies of the writ petition
7th
be served upon the learned counsel for the respondent. Let steps be taken for service of notice upon the respondent number 5 by registered post PTD. Steps by tomorrow. Thereafter, registry is also directed to tag the additional affidavit along with the record by the next day.
Obliged. The primary question in this petition, whether NPS will be applicable to employees who are appointed before the amendment. Initially, two coordinate benches has taken a view, we came up for a similar order. Now recently there is a judgment. They has taken some other view. Lordship, we are examining the judgment. It is pretty long, Lordship.
Mr. Bora, what is this?
My lord, regarding this is, these petitioners are OBB teachers, my lord.
They are Hindi teachers,
OBB teachers.
OBB teachers,
My
right?
lord, here a judgment passed in Purnima Horo, my lord. 2406, 240321, in the March of 23. Huh? Six,
No, we are not on the numbers or the names.
my lord, here.
He has
my lord,
made a statement that there
they are
are,
not eligible for my lord.
no, there are different judgments.
My lord,
All the
but-
judgments are against the petitioner.
my lord, here OBB teachers, but let judgment, my lord, OBB teachers are not entitled for one old pension under the old pension scheme.
Oh, exactly on the OBB teachers.
My lord, only stipend teachers are entitled. Appeals.
In that case, where is that? What is this? Where is the scope to examine?
No,
Has
Lordship,
that judgment been put to appeal?
My lord,
Huh?
my lord,
That has been challenged.
my lord,
Yes.
there is pending, my lord.
yes and no, Lordship, the primary question is that whether teachers appointed before the amendment of the rules would be covered by NPS or the old pension.
That is the question which has already been answered.
No, two benches have already said that teachers appointed before the amendment would be governed by the old pension.
Let
scheme.
us see the judgment.
Yes. Yeah,
What do you say, Mr. Bora, on this aspect?
My lord, appeal is pending, my lord. let
No, no.
appeal is- my
He's
lord,
trying
let-
to make a distinction.
My lord,
He's trying to distinguish this case
my lord,
to be one where appointments were made prior to the amendment.
my lord,
So he contends that it is the old NPS, old pension scheme,
my lord.
which should be applicable, not the NPS. And there is a judgment on that, in that regard. What do you say?
2-3 judgments.
But as per Purnima Horo, my lord, OBB teachers are not entitled, my lord.
Now, is the issue relating to OBB teachers
My lord.
or teachers?
Let the division bench may decide regarding.
No,
this,
no,
my
no. You have to clarify one thing.
My lord,
The case which you are referring to,
my lord.
is it connected to OBB teachers or is the issue involved prior to or post amendment? We may not be too much interested in what teachers they
My
are.
lord, my lord,
We will be interested on the application of the new pension scheme,
my lord,
whether they had come into the services prior to the amendment or after the amendment.
my lord,
If they're after the amendment, there is no issue.
my lord,
You have appointed under this condition, NPS.
Right.
But if you are an existing employee,
my lord.
when the amendment had come in, whether you can give retrospective effect to the amendment, that is the question.
Their initial appointment on the scheme, my lord. No. OBB teachers are on the scheme, my lord. It is where their appointment may not be considered as continued, my lord.
Let us take this matter after sometime senior council. I am led by senior council.
Okay, then we'll have it after the vacation.
My lord,
We'll do one thing, we'll issue notice. No, we don't like a matter of 22 to be listed for motion. Okay.
Yeah.
We'll issue notice of motion formally, have it for admission.
Yes, sir.
Third, BP Bora, and council for the petitioners. Full stop. The petitioners who are teachers appointed under the Operation Blackboard scheme, within bracket OBB, are aggrieved by the action of the respondents in applying, in treating them to, in treating their appointments to fall under the new pension scheme Full stop. The learned counsel submits that their appointment was prior to the amendment of the Assam Services Pension Rules 1969, which was done on 14/7/20
47 to
2011.
2011.
Full stop. Para. On the other hand, comma, Sri P.K. Bora, the learned Standing Council, Elementary Education Department, has submitted that the cases of teachers under the OBB scheme has already been decided that they are not entitled for pension under the old pension scheme. Full stop. Para. Let notice of motion be issued, returnable by 4 weeks. The P.K. Bora, the learned Standing Council, Elementary Education Department accepts notice on behalf of respondent 1,
And 7, my lord.
1 and 7, pension, MSD Das Burman,
Respondent
State Council for respondent number
2 and 3.
2 and 3, Finance, Chaliha, Finance 4, 4 and 5, 6 also, I think. Pension, you have already taken pension. And Inspector of Schools already taken. So, 1, 2, 3, 4, 5, 6, 7 already. So, बाकी रह गए. Six, Finance and Accounts Officer, pension, government, Didas Burman for 3 and 6,
3 and 6.
2, 3 and 6, correct. Returnable, 6 is good.
Lordship, Lordship may
Let extra
fix the
copy.
date. Maybe Lordship may fix the date if possible.
কি বলে দিছে? Let extra copies be served by tomorrow. Okay, sir. 22 matter. List on 28 to 8. 28/7.
Obliged.
Mr. Khataniar, your colleague is referring to paragraph 18 of the order passed by this court while issuing notice. So not issuing notice, while considering this case
Yes, my lord.
on 10th of
Yes, my lord.
February. He says that observation, if finalized, will bring an end to this proceeding. Are you agreeable?
But, yes, I want to go through it, my lord, once. Because, my lord,
You go through it
my lord, may take it up after some time.
after 15 minutes,
Yes, my
after
lord.
3-4 matters.
Yes, my lord. In the meantime, I will go through it. my
Yes, sir. You have you take
Yes,
the
my
court record.
lord. Obliged.
Thank you.
My pleasure, Lordship. Matters related to drop teacher, Lordship. On last occasion, when the matter was listed, the Honorable Court, by order dated 14/11, was directed, asked us whether the petitioner submitted their application in response to advertisement published by the Education Department for judgment in 19/1, 2003, Lordship. Then after that, passing of that order, whether we have filed any application or not, Lordship. And in that response, Lordship, to the Honorable Court query, we have filed an additional
Additional
affidavit,
correct.
Lordship. There, we have already annexed those communication document. Affidavit form.
Ito na. Ito na. Ito ba ito mo?
They responded to the advertisement, Mr. Khataniar.
Because I'm
We'll do one thing, instead of this hanging at the stage of motion, we'll issue notice at this stage, let's
Dispose of lordship.
dispose of. We'll dispose of at the admission stage.
admissions.
Later lordship.
We'll dispose of the admission stage.
Yes, my lord.
Let him have the instruction.
Yes, my lord.
Have you taken instructions on the additional affidavit?
Yes, my lord.
What is your instruction?
No, I have just now gone to the.
You
affidavit,
go
but
to the affidavit. additional-
I'll obtain.
Because the anxiety of the court was that whether it cannot be an endless process.
Yes, my lord. In fact,
Whether
we
they
will-
had actually applied for it.
Yes, my lord.
Now in the additional affidavit, they have stated that they had applied.
Yes.
So in that case, probably, if you have the instruction, dispose of
Yes,
the
my lord. Whether their application.
Today itself, lordship, please, because communication is already there, lordship, allow the order will file a fresh representation, lordship.
Well, after the vacation, we'll fix it.
Yes.
Lordship.
Third, Reyes Munir Learned Counsel for the petitioners who claim to be rendering services as assistant teachers, assistant teacher and Hindi teacher respectively in two different schools which were provincialized, but their cases were not considered. Why have you amalgamated two actions? Separate schools, separate orders of provincialization.
Because the lordship, as per the communication, lordship, their name appear in the same.
Doesn't matter.
That is
There
why-
may, one order may cause names of 3-4 employees as a dismissal order, but will it give rise to a common cause of action? No. Different schools.
School
I did-
is different.
Had it been same schools, both in the Kachar district,
Lordship.
you should file two applications. We are not saying anything at this stage, but this is not the process. Sri Munir, the Learned Counsel further submits that pursuant to an order of this court, comma, on 7/2/2023, comma, an additional affidavit has also been filed to bring to the notice of this court certain documents in connection with certain documents, certain relevant documents. Issue notice of motion returnable on. We'll fix a date
Yes, my lord.
on 24th of July. 24th of July. Sri N.J. Khatanir, Standing Counsel,
Secondary education, my lord.
Secondary Education Department, accepts notice on behalf of respondent numbers 1, 2, and 3, all the rest.
All
1, 2,
the
and 3.
rest.
Let extra copies be served upon him by tomorrow. Additional affidavit you have served already?
Without serving,
No, no.
Yes,
Do you need an additional copy?
Yes, my lord. In fact, I have collected another copy.
That initially at the time of filing.
Not for taking notice, give an additional affidavit copy. These are part of the pleadings. So
Lord,
Obliged, lord.
much obliged, sir. Much obliged.
eleven.
Here, my lord, petitioner has already accommodated as tutor, my lord.
Gogoi,
Last time,
tutor. Happy.
was it?
Happy with a tutor as a tutor.
Tutor is a
No, was it that,
Not happy.
that appointment I challenged you.
You have challenged separately.
That's it.
So this has become infructuous.
This is not in fact.
Why?
After appointment as a tutor, I challenged
So this is the challenge as a tutor.
tutor.
Okay, this is the case.
Earlier time, I am a regular teacher.
Then what is this instruction? He's already put to challenge.
My lord, then notice may go.
Will formally issue notice. Okay. Third, Sri L. Gogoi Learned Counsel for the petitioner who has put to challenge the put to challenge an order dated 30/1/2021 by which the petitioner has been appointed as a tutor without any retirement benefit. Full stop. It is the case of the petitioner that he was initially appointed as an assistant teacher at the Jorkata Naharani LP School in the district of Dhemaji in the year 1989. And his services were regularized by an order dated 13/3/1995 retrospectively. Full stop. Thereafter, the petitioner was transferred and was getting his regular salaries in the revised scale of pay up to September 2007. Full stop. However, thereafter, his salaries were stopped, leading to a number of litigations and as well as contempt petitions, whereafter the present order has been passed. Full stop.
He joined as a tutor also, my lord. He has received the first salary also.
Doesn't matter. There are, on the other hand, the P.K. Bora, the Learned Standing Council, Elementary Education Department has submitted that the petitioner has joined as a tutor pursuant to the impugned order dated 13/31/2021 and has also been receiving his salaries. Full stop. Para. Be that as it may, let notice of motion be issued, returnable by 4 weeks. 3. Bora, Standing Council, Elementary Education Department, accepts notice on behalf of respondents 1,
For all the.
2, 3, 4, and Board of Secondary 3 and 4.
Board of secondary is not required.
Now it has been added as a party respondent by the court.
Unnecessarily alert that order.
It's by the court. Can I say anything?
Already served notice.
Names shown or not? Anyone? Who is for Seba?
T. Sutia, my lord.
Oh.
This is
This is.
None appears for the, let extra copies be served. Extra copies of writ petition be served upon Sri Bora by tomorrow. Let extra copies also be served upon the Standing Council Seba, who however is not present in the court today. Last one can be also be served on the Standing Council Seba. The objection raised by Sri Bora regarding joining of the petitioner as tutor would be considered at the appropriate stage.
Obliged. Compassion.
Yeah, please, my lord. And here in this case, my lord, compassionate appointment, I am praying for similar order, my lord, passed by this honorable court in WPC number 1646 of 2021, my lord. And your lordship may,
Why review?
the review file, my lord, initially this honorable court passed the order, that was
What was the order passed on 1st of March 2023?
that was without setting aside the minutes for meeting, my lord. So I have preferred the review, my lord, and this honorable court allowed the review on 4/5/2023, my lord. In fact, director PLC, my lord, since I have challenged the SLC order, my lord.
Yes, who is there?
Page number, you know?
Mine submitting at page number, my lord, 37.
Heard the I alum, learned counsel for the petitioner, put up. Para. It appears that this matter was disposed of on 1/3/2023 at the motion stage. No, don't say. 1/3/2023, whereafter it was reopened by order dated 4/5/2023 in review petition number 46 of 2023 filed by the petitioner. Full stop, para. The matter pertains to a claim for appointment on compassionate ground. Full stop. The claim of the petitioner was rejected by the state level committee
My lord,
in its meeting held on 26/8/2022, in spite of the recommendation by the district level committee. Full stop, para. That notice of motion be issued returnable on 28, 28 तारीख. No, 26 तारीख, 26/7
my lord.
2023. MS Leaders Burman, that on the state council,
Correct.
accept
File number
notice on behalf of respondent numbers
1 and 4.
1 and 4. PK Board of 4, 2 and
2, 3 and 5, my
2, 3 and 5. Extra copy by tomorrow.
Oblige.
Yes, what is this?
Yes, ma'am, I have gone through the order, madam. I've seen there is a detailed order regarding, madam, which year is to be counted as the previous year one. But madam, from this, since I don't have any instruction why his case was not considered. In fact, in his petition, page 39, he had given a chart year-wise number of enrollment in respect of economics subject matter. And his contention is that in the year 2016, total API had 9, and because of that, his case was not considered. So may I have a
We can do one thing. This is at the motion stage.
Yes, madam.
We'll issue formal notice.
Yes, madam.
And since this matter
It's a 23 matter.
is, there's some orders were passed on the last occasion,
Yes,
which you given you a guideline how to proceed, or given the parameters on which it will be considered.
Yes,
You take instructions on this?
yes, madam.
My lord, if your lordship permits, my lord,
Yes, yes.
the time they require, it may be given. Only let them get the instruction. I think that will be enough.
No,
Because-
we'll fix a date and we'll try to dispose of the admission stage.
Yes, madam.
Heard through J. Abedin, learned counsel for the petitioner. Full stop. The grievance of the petitioner is with the action of the respondent authorities in failing to give her the benefits of provincialization of service.
His-
His provincialization service pursuant to section 4 within bracket 1 of the
2017 Act.
what is the name of the act? Name of the act.
The Assam Education Provincialization of Service of Teachers and Reorganization of Educational Institutions Act 2017.
Okay, sir. I recall.
My lord,
The
that will-
learned counsel has also drawn the attention of this court to a previous order passed on
10 to 2000.
passed by this court on 10/2/2023, as per which certain findings were also arrived at as recorded in paragraph 18. That notice of motion be issued returnable on 26th of July 2023. Sri Sanjay Khatuni, Learned Training Council, Secondary Education Department accepts notice on behalf of responsible 1, 2, and 3.
Yes, my lord.
Inspector of Schools,
Yes, my lord.
1, 2, and 3. Let extra copies of the petition be served upon him by tomorrow.
My lord, only thing, as my lord has mentioned in section 4.1, that is another read with 3.7 also, my lord.
Of the same act,
Yes, is the 3.7 covers my case.
for one read with 3.7. 3 within bracket 7.
3 Roman 7.
Obliged, your lordship.
Deeply obliged.
এখন আবার তাইলে
I think. May it pleases your lordship, can be taken after some time, lordship.
Lordship, on the last occasion, Lordship, they have sought for time to file an additional affidavit. That has not been filed, Lordship. And it's a 2022 matter. Till now, Lordship, notice has not been issued, Lordship.
will issue notice if it's a case.
Lord,
Why health matter, why is it come here? Assigned to this bench over. Bench 2. Connected with education over.
Yes, Lordship. Connected to Hamak College, Lordship.
College.
Yes, Lordship.
What is the issue involved?
Lordship, there was a penalty imposed, Lordship, to the petitioner, Lordship, at page 88, Lordship.
They are the college. No.
No, Lordship, it's a pharmacy, Hamak College of Pharmacy and Dental Medical Sciences. For starting of B.Pharm.
Madam, what are your grounds of challenge?
grounds, lordship, that
Where is your brief?
brief is not with me, lordship. but
Why?
It is with my senior and he is on the way, lord. Lordship, the major penalty was imposed upon the petitioner and penalty was reduction to lower
That
grade.
we know, but what are
And,
the grounds of
lordship,
challenge?
the finding was based on presumption only. No specific evidence was there against the petitioner. That's why we approached this.
Was there a disciplinary proceeding?
Lordship, yes, lordship.
There was.
Inquiry was made against the
15. Lordship, charge is also filed, Lordship, page 52, and the statement of allegation at page 54, Lordship.
Enquiry was held.
Yes, Lordship. And on the last occasion, Lordship, they have.
Your BDB,
Yes, lordship.
heard BDB learned counsel for the petitioner, who by means of this petition has put to challenge an order dated 28/11/2022, whereby the petitioner, who is serving as a lecturer of the Institute of Pharmacy, Assam Medical College, Dibrugarh, has been imposed the penalty of reduction to lower grade. It is submitted that the same penalty has been imposed without there being any specific materials against him and on the basis of presumption. On the other hand, D. Upamanyu, Learned Counsel appearing for the Health Department, has submitted that the materials would reveal that the penalty was imposed after following the due process of law. Let rule be issued. The Upamanyu, the Learned Training Council, accept notice on behalf of respondents 1, 2,
All the respondents.
all the respondents. Let extra copies of the petition be served upon him by tomorrow. List after 6 weeks for orders.
Lordship, similar order in the next matter, item.
Item number
Similar.
16.
So what is the penalty?
Same penalty.
Date,
They
Same
same everything.
give copies by tomorrow, madam.
Lordship.
Very good.
Highly obliged.
Obliged.
Good work. No. No, been-
Lordship. For timing, Lordship, my senior leg for 2, Lordship.
Who is your senior, madam?
Mr. M. Khan.
M. Khan.
Yes, Lordship.
But 15 matter, will not adjourn this matter. Sir, punish it.
After some time, Lordship.
Okay, ask him to go.
Lordship,
18, what?
this case is, petitioner is appointed after provincialization, Lordship, and Lord. No, honorary as honorary basis, and private respondent is appointed after selection process.
What is your challenge, madam?
Actually, your Lordship, my senior is on legs.
Hmm?
My senior is on legs.
Who is your senior?
As Patia.
You are not aware of the facts. Why? Is there a difficulty in reading the brief? You have the brief before you, you should know the facts. If not the law, at least the facts, those are not so difficult. Come prepared with the facts next time. Okay, don't just carry the brief. We're sitting in the court for half an hour. Would have read the brief. Read the brief. This is the 16 matter. If your senior doesn't come, we'll ask you to narrate the facts. Okay, after some time.
If
Brief is it to you or not? The brief is of this case. Read it. Yes, next. Not now, after some time. Nothing like.
May it please your lordship.
Hmm.
My lord, my lord, the petitioners are represented by the Permitted Madrasa Teachers Association, your lordship. There were altogether 14 numbers of pre-senior institutions, your lordship, are left out from recognition, your lordship. Although the similarly situated pre-senior madrasa already been recognized, your lordship, it is only because of the fact that at the relevant point of time, your lordship, the board was not in existence, your lordship. In the year 2008, your lordship, the madrasa board was dissolved. And because of that, your lordship, we have been left out, your lordship. We have all the requisite qualifications, your lordship, for provincialization, for recognition.
And now, is there any cause of action after the development? Sharma?
My lord, now it is new act has been come, my lord. So now madrasa are also converted to higher secondary.
Yes.
So my lord, I think it is. no
Is there
problem.
any live cause of action?
Yes, your lordship, the madrasa recently.
Now, can we give you any relief in this after the conversion?
So, your lordship, may kindly be disposed of, your lordship, a direction may kindly be given, your lordship. If others are not eligible there, the institution, then your lordship, the department or the government will do the needful, your lordship.
Because this matter is pending since 17.
Lordship, lordship.
Now, when was the decision there to convert to higher secondary school?
My lord, new act has been come and my lord, madrasa has been abolished. So with the new act of the come, my lord, it is abolished, my lord.
But
What was the act? When one was it? Heard 3,
but the,
AD1, Learned Council for the petitioner. Also heard 3, U Sharma, Learned Training Council, Secondary Education Department. Also, this matter, which was filed in the year 2017, is pertaining to the aspect of recognition to the institute, to the madrasa institution under the petitioner association. It is the case of the petitioner that instead of the institutions under the association having fulfilled all the requirements for such recognition, the benefits, the recognition, they were being deprived from the same. And therefore, this petition was filed in the year 2017. On the other hand, Sri U. Sharma, the Standing Council, Secondary Education Department, has submitted that there is no live cause of action as all the madrasa institutions in the state of Assam have been converted to higher secondary school, and therefore, as on date, the issue has become redundant also. This court finds force. In this connection, the learned counsel for the department has referred to which act? They referred to the
1995.
no, whereby you have converted. I have referred to the under which the aforesaid action has been taken by the government as a matter of policy. This court finds forth in the contention of the learned counsel for the department that since the existing madrasa institutions have been converted into higher secondary school, there may not be any cause of action existing to be decided in this case. Accordingly, this petition, this court, while closing this petition, makes an observation that if, but the conversion has been done long time back. Where is the scope now? Where is the scope for consideration?
Lordship, since we have been working in this, all these institutions since 1996, and after that also is lordship. So what will be the fate of the teachers if those?
No, teachers are not before us. The teachers are not before us.
Teachers are not before us because the teachers are represented, you lordship.
No, the institutions.
Institutions are, because in the institution, you lordship, they are teaching staff, and
We cannot go down. The teachers will have students. Then the students, teachers will have their family, then children, grandchildren. Can you just extend this? Are we making an inquiry into this case on behalf of somebody else? We only recognize the persons who are before us. Because this court accordingly closes this petition as the same is without any existing cause of action. Yes, next. Next. (17) 190.
The story, Lordship, I was in lack in.
It's been matter, yes.
My lord,
Last occasion also you were not present.
my lord, what happened, Lordship, in this case? The school was established, Lordship, in the year 1996.
What is the issue?
My lord, issue regarding the Lordship granting permission. My lord, permission was granted on.
You are there. Who's there? Government education? HS school.
is a lordship. Higher secondary school. That was introduced, established lordship within the campus of high school.
Okay.
Thereafter, application was submitted lordship in the year 1996 for upgradation of high school to higher secondary school. And
You were aggrieved by 4/4/2014.
my lord,
Your claim has been rejected.
that has been rejected.
What are your grounds of challenge?
My lord, what happened, lordship, under similar circumstances to lordship, our high court lordship has granted relief, that is your lordship will find page 29.
Annexure 8.
My lord, annexure 8.
Now, what are your grounds of challenge? We'll see the similar order.
My lord, what happened after introduction of the lordship establishment of the school, we filed application on 12,
Let us see the 4/4/2014 order.
my lord,
Where
that
is
is
it?
page 24,
2/4.
my lord.
Page 20.
24 lordship. May I refer?
4/4.
4/4/2014.
Yes.
Well, this is a case taken up as per direction of the Honorable Guwahati High Court, height number so and so. And on the basis of representation dated 9/4/2012, filed by the principal Rangati Girls Higher Secondary School, by to praying for condoning 19 days delay, and under the provision of Assam Venture Educational Unit.
Where do you find 19 days delay?
My lord, this
Delay, where is the word delay?
my lord, ground was lordship,
Now, where is the word delay you have read?
my lord,
Just now you have said delay. Where is the word delay?
my lord.
No, 19
So condoning 19 days lordship,
There is no delay.
lordship, yes.
You have said delay now.
Lordship, praying for condoning 19 days, and under the provision of so and so, Act 2011, by so and so, Venture Educational Institute, which have been accorded permission on or after 1/1/2006, shall not be provincialized, and no such educational institution shall be allowed to remain functional with condition so and so, so and so. Services of employees of the Venture Educational Institute which have been established,
That means a date has been fixed on 1st of January 2006
my lord,
to give provincialization.
provincialized.
You were established after the date.
My lord, permission was granted on 20 January 2006,
That is it, 19 days delay.
19 days, lordship. That was, pray for condoning the delay of that 19 days. My lord, what next, lordship, kindly, there is the last part of this page, lordship. In the instant case, lordship,
Yes.
in the light of papers, document as submitted by the school authority, including representation dated 9/4/2012, the Rangati Girls Higher Secondary School had fulfilled all the requisite conditions for being provincialized, except the permission which was accorded to them by the government in secondary department by number so and so dated 21/2006, with effect from 21/1/2006, and as such, it is found that the school had obtained permission beyond the deadline of 1/1/2006 by 19 days. Being aggrieved of this very fact of 19 days, the school authority filed the representation dated 9/4/2012, praying for condemnation of 19 days. Meanwhile, we have sought views and comments from Judicial Department, height number so and so, Judicial Department so and so. Their comments stating that the department has no power and jurisdiction to relax any provision of Assam Venture Educational Institution Provincialization Act 2011. Under the above circumstances, the representation dated so and so for condoning 19 days hereby rejected. However, for allowing institution function, the inspector of school Hailakandi be directed to submit press report. Although the Act of 2011 has been struck down, the same clause has been inserted in 2017. So we are lost if the issue is still surviving. After lordship introduction of establishment of school in the year 1996, we filed application on 12/9/1996. That was not considered. We filed a writ petition on in the year 1999. Lordship, that is.
No, that has been narrated, that it has been considered pursuant to the orders passed with the writ petition. In the narration part,
My
for- first part, that the consideration is per 7/27/2012. First line itself
first line.
of the order of 4th April is
Consider-
24.
Prior to that, we have filed several writ petition lawsuits.
Understood, but this consideration has been done as per 9/4/2012. As per the order passed by this court on 2/7/2012, right?
Yes, Lordship.
Now you are referring to a common a judgment of this court.
Yes, Lordship.
Similar.
That is Case Lordship 29.
Yes.
Case 29,
Mm.
their Lordship issues.
Mm.
Lordship, the second paragraph of case 30. Second paragraph of case
Yes.
30, Lordship. These writ petitions are filed by three schools, namely so and so, for a direction to the respondent board of secondary education Assam to grant the recognition of their school with effect from 1/1/2005, 1/1/2006, and 1/1/2006 respectively, containing inter alia that though the inspector of school as well as director of secondary education recommended the recognition of the school with effect from those dates, such recognition, however, was given by the board with effect from 1/1/2007, thereby depriving them from the getting the benefit under the provision of Assam Dancer Educational Institution of so and so. It is also the case of the petitioner that committee constituted by the board to look into the grievances of the similarly placed school also recommended according the recognition to the petitioner school with effect from 1/1/2005 and 1/1/2006, whose recommendation, though the board has accepted in its proceeding dated so and so, dates of recognition, however, has not been modified accordingly. The petitioner therefore have approached the court with relief. My lord, now your lordship may kindly come to the operative part, case 32.
Yes.
Since the board has accepted the recommendation of the committee, constituted necessary benefit has to be given to the petitioner, and hence the writ petitions are disposed of, directing the respondent Seva to pass necessary order, giving the recognition to the so and so school, so and so, and Molai High School with effect from 1/1/2005, 1/1/2006, and 1/1/2006 respectively. The said order shall be passed by Seva within a period of 2 months. Subsequently, lordship, another order, a lordship, they filed a review against them. That has been dismissed.
Yes.
My lord, the state filed the review, that is page 33. 34 is the relevant, that has been dismissed. Subsequently, they have complied with the order. That is page 35. Relevant is page 36. These schools were granted recognition with effect from 1/1/2007. Subsequently, lordship, that has been modified. Page 36, lordship.
Yes.
In the three school, lordship, first school 1/1/2006, date of effect is given. Second one is given 1/1/6, and third one is 1/1/2005. And apart from that, I have brought some other judgment.
But the cases, the facts are different.
My lord, this case,
Here, there was a clear finding. There was a recommendation to accept the dates of provincialization with effect from 1/1/2005 and 1/1/2006, in spite of which the recognition was given on 1/1/2007, which was after the cutoff date.
Some, Your Lordship, some.
Then where,
differences.
there is no similarity with the facts in your case.
My lord, these two cases presently Lordship that we have given, this will squarely cover my case. In Panigaon Higher Secondary School, Your Lordship, kindly,
Yes.
Panigaon Higher Secondary School.
Hmm.
Second paragraph.
Yes.
The case of the petitioner is that science and art system of the school has been provincialized in the year 1984 and 1992 respectively. On 1997, a letter was forwarded by the government of Assam to the Secretary Education Department for according permission for opening an additional stream in the higher secondary school along with two others. The feasibility report submitted by the inspector of school in Sar, Lakhimpur district to the respondent number 2 has recommended the opening of commerce stream from the next academic session. Similarly, on 7/4/2000, a feasibility report for upgradation of high school to higher secondary school was submitted from the secretary Assam High Secondary Education Council to the Commissioner and Secretary Government of Assam. The name of the school find at place 12, which clearly indicate that the petitioner school has fulfilled the eligibility to open an additional stream of commerce. The report for opening additional stream has been kept pending for the last 7 years. Ultimately, the government accorded recommendation on 12/1/2006. The grievances of the petitioner is that till now the school has not been provincialized. According to the petitioner, many schools got approval from the government, but the petitioner school has not been provincialized till now.
See, here we have an order which has rejected it. We have to adjudicate the validity of whether that order is valid, invalid, legal. Their order, there was no decision taken. On the other hand, the court has recorded that the governments, many schools had got recognition, but you did not. And it was on other facts and circumstances.
But
you have a clear-cut case where your provincialization is given from 21/20/26, 2006.
My lord, there in this case, Lordship, so for the feasibility, Lordship, the Panigaon Higher Secondary School, here, Lordship, recommendation was made on 12/1/2006. Subsequently, the court has directed the authority, last paragraph. Consequently, the respondent number 1 is directed to Lordship, last paragraph.
Yes.
Consider the case of the petitioner as projected in its representation dated so and so for changing the date of its recognition with effect from 12/1/2006 to 1/1/2006.
You just cannot ignore the first part of paragraph 12 in Panigaon.
My lord,
12/1 has come only according to recommendation after the science. Just read the entire paragraph again. Case of the petition is that the science and arts stream of the school has been provincialized
yes,
in the year 84 and 92.
92.
On 97, letter was forwarded for according permission opening an additional stream in the higher secondary school along with two others.
My lord,
Feasibility, this is for only for the additional stream.
my lord.
Otherwise, science and what was the commerce? What is science and arts? 84 and 92 itself. There was a list of 2000 in which the name of the school was there at serial number 12. Do you have any existing some similar facts in your case?
My lord, Kazai Lordship, another one is given.
No,
Lordship.
in your case,
My lord,
in the case which you are projecting, you are appearing,
my lord.
is there any such a report of earlier time where your name of the school had appeared?
That Lordship feasibility report, Lordship, that is there.
Page
Lordship, I mean, page Lordship 18. My lord, page 16, sorry, Lordship.
16.
16, Lordship.
Yes.
This is the letter from Assam Higher Secondary Education Council to Commissioner Secretary. I have the honor to inform you that after receipt of government instruction, Council started the process of obtaining feasibility cum necessity report of provincialized high school by inspecting the school after receiving application in prescribed form with requisite fee, and the council forwarded 105 such high school to the government. But the council had to keep in abeyance all remaining cases for taking necessary action. Following the receipt of government ban by letter dated so-and-so 6/8/1997. In the instant case, though the school applied to the council in the prescribed form with requisite fee on 12/9/1996, Lordship.
Where is the report by the
Hello.
retired director?
My lord, report,
Read by the retired director, last paragraph.
my lord. My lord, I am starting from second paragraph.
Last paragraph, meanwhile.
Meanwhile, the school approached the Honorable High Court, and the Honorable Court directed the council to take up the matter. Accordingly, the council got the school inspected by an eminent educational Sri so-and-so Chaudhary, and report in original is forwarded here with.
Where is the report?
My lord, that report I have available, that copy, that has not been annexed, Lordship. I have the copy,
What has been stated there?
my lord.
Mr. Sharma?
My lord. Current here he is taking for provincialization of 2011 Act, and which was struck down already. And my lord, now my lord, if he want to provincialize now, he come under the new act. My lord.
17 Act.
Yes, my lord, 17. Then he can provincialize his stuff, my lord.
How do you deal with this?
My lord,
11 Act is not there.
No, my lord.
11 Act is not there, but my lord, the bar which was imposed in 2006, that is also imposed in 2017 Act. That is also, there is a cutoff date 1/1/2006, Lordship. Earlier, several occasions, Lordship, we approached before this honorable court, and court directed the authorities to consider the case.
My lord, in these circumstances, he has to approach the authority for provincialization or whether they considered or not. After examining all this, they will decide.
11 Act is not there. Where?
That is
Consider,
correct.
consideration under what now?
My lord, so far bar is concerned, that is there.
No, consider under
Your
under what now?
Your Lordship may not direct to the authority.
My lord, he is referring
to provincialize the service.
at
Your
2017.
Lordship, your Lordship set aside the impugn order with a direction to treat the recognition with effect from 1/1/2001. Then it will, Lordship, they can approach the authority, Lordship, for provincialization.
But there are many cases on cutoff. You cannot just term a cutoff to be unreasonable. Ultimately, there has to be a cutoff.
My lord,
It
that
should
is-
be an unending process.
Well,
You say 19 days. Somebody may come tomorrow, 25 days, 30 days. It's been settled. The cutoff is cut off. One day, maybe less, more. You are not. If you miss the bus, you are missing the bus.
My lord, under similar circumstances, I have given another judgment. That is Kazaikata PM Academy Higher Secondary School.
Yes.
In that case also, Lordship, 7/1/2006 was the Lordship, that was the date. But subsequently, Lordship directed the authority to consider their claim. Accordingly, Lordship, they have considered. That is the.
What are the consideration?
Well, that is given, Lordship.
You should place this on
There-
record by affidavit.
Their school has already been provincialized. Panigaon and Kazaikata, Lordship,
The scrutiny committee is the view that a case may be examined in the state level committee for provincialization in the light of the High Court. Where is the examination on order? This is only a recommendation of the, in terms of the High Court. The discussion of Kazaikata,
My lord,
it is only referring the matter to the state level committee for consideration as per High Court. Where is the actual condonation part?
my lord, they, as I informed lordship, their school has been provincialized.
You have to
That
take
is
this.
not on record, lord.
If you are having some information, at least you have to give that information in by way of an affidavit. The difference in this case is that there is already a speaking order rejecting your claim on the basis of delay of not meeting the
My lord,
cutoff.
my lord,
Now, to challenge that, you need to have grounds that cutoff, fixation of cutoff of 1/1/2006 is not proper, reasonable, or they have not stuck to this cutoff. They have been giving the benefits to others, not to you.
my lord, can it be taken up after vacation lordship? In the meantime,
15 matter.
I will file lordship additional affidavit enclosing all the document lordship. Any date lordship immediately after it. I'll place on record. Lord.
Sharma,
Yes, sir. My lord, section 3, my lord, eligibility criteria for the selection of educational institution for provincialization of services and services of teachers and tutors act. 108 page number, my lord. This is Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. So here, my lord, 3.1 clause 3.1. So provided further that the order of such permission recognition concurrence shall have to be issued on or before 1/1/2006 and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teacher, tutors, as the case may be of the institution.
that is a statutory requirement now.
My lord.
Yes.
Then how do you overcome that?
My lord, that is the case. Lordship. Earlier one was the same thing lord, in 2011. Actually. My lord, there was no call on the part of the lordship petitioner. We have lordship constantly.
But this is a part of the statute. Unless you challenge that part, the power has been totally cut off. There is no power to condone. There is no question of condonation after 1/1/2006.
That's so far the judgment of this honorable court lordship.
Is it
Similar-
after, is it in after the 17 Act?
My lord.
There was no consideration for the 17 Act.
My lord, the same provision was in the Act of 2011.
Now, the cases which you have placed before this court, there is no speaking order in those cases which were the subject matter of challenge. It was at a prior stage, at the time of examination. Now there is an examination pursuant to a court order, which culminates in a order of rejection on the ground of not meeting the cutoff. Now you have to, if you
They-
challenge,
They rejected my prayer on the ground that they have no scope.
yes,
That is the ground.
yes, there is no scope.
My lord, so far judgment. My lord, may I pray lordship, this all these records lordship, I may be allowed to bring out to the
15 matter we are not going to adjourn. This is not the purpose of listening to this.
lordship. These otherwise these documents are lordship will be the vital documents. Lord. Because Kazaikata case lordship that has been considered, if possible lordship, I will place that consideration also lordship. Any date lordship immediately after that.
No, we are not adjourning this matter.
My lord, to this consideration lordship. under
See,
C-
Mr. Islam, this is a matter of 15.
My lord, correct.
If you wanted something to say, you could have got all the time
My
from
lord,
15 to 2023.
This
You are
was,
seeking an adjournment after the hearing is over.
my lord, whatever lordship.
Sorry, we'll
This,
pass order.
in this case, lordship, the case was dismissed for default lordship. Subsequently, while review.
We don't know all these things. 15 matters before this court.
Lordship.
If we adjourn this kind of matters, a very wrong signal will go. If you don't give priority to a 15 matter, we can't help.
Lordship, can you
Heard.
Friday or no, Friday lordship, as part of.
We'll be passing orders. Heard. I am Islam Learned Council.
M. Khan.
M. Khan Learned Council for the petitioner. Also heard. Three, U Sharma, Learned Council, Learned Standing Council for the Secondary Education Department. Anyone else? D. Das Burman, State Council, D.K. Roy for Assam Higher Secondary, Higher Secondary Education Council. Mr. Sharma also you're appearing? No. Chaliya, at Finance. B. Gogoi, Finance Department. Matter has been heard and considering the fact that the writ petition is of the year 2015, the matter has been heard at the admission stage and orders are reserved. Yes, next.
And not the document, what I have given was,
We'll read this.
I will furnish the photocopy. I'll take it.
Oh, yes. Give all the judgments.
My lord, I will give.
Item,
May it please your lord.
again 16 matter. Yes, what is it?
My lord, on the earlier occasion, my lord, this court directed us to get some instruction from our client, my lord. But we are unable to contact our client. To get
What is the
instruction-
matter about?
My lord, we have challenged the regularization order of the respondent number, my lord.
9.
9, my lord.
Who is the- yes.
Both of us, the petitioner as the respondent number.
You're for the
9.
respondent number.
Yes,
9.
respondent number 9, we were appointed as honorary teacher. Thereafter, a selection procedure was held. In selection, I was selected and I was appointed in a Rajagar ME school. But that post was meant for a Hindi teacher, lordship. Accordingly, I have again been appointed in the earlier school where I was engaged as a honorary teacher. He is challenging that I have been regularized as an honorary teacher in that post. That is the case. But we have under a selection procedure, I appeared in that selection procedure and I was selected and I was appointed. And the query made by this honorable court to the writ petitioner was that whether he has appeared in that selection process or not, but that was never been reflected in the writ petition and he is unable to get that query till date. That is the case.
And I have annexed the selection list, select list lordship, Rameshwar Goyari, at page
Which is the school in
63.
which is the school in question?
Uttar
Sir,
Shekhar,
Sekhar ME school.
Uttar Shekhar ME.
Sir?
And what were appointed as honorary by the school managing committee initially. And respondent number 9 appeared in the interview.
Just a minute. 1595, he says that he was appointed.
Honorary.
Petitioner.
Both
Respondent number 9 is much junior to him, my lord.
both of them
Appointed as honorary.
honorary.
And as per you, the respondent number 9 was appointed in the year 98.
Yes, ma'am.
R9. The school was a venture stage.
No. Then also it was provincial.
Provincialized.
Provincial
school,
school.
Provincial.
Then he says that his services have been regularized in spite of the fact that he is junior.
Junior. But lordship, fact is in the year 2005, advertise was called for and financial approval was received lately. So 2015, lordship respondent number 9 is appointed after appearing selection process. He has not appeared in the interview, Lord.
When
Not-
was this?
Not applied. for.
You have filed affidavit.
Yeah. He also filed.
H. Sharma.
In
R9.
paragraph 8, lordship will get the whole fact of my evidence.
And BTC has also filed affidavit.
Yes, Lord. We have stated everything, Lordship. We have annexed the list also, Lordship, and we have stated in paragraph number C of our affidavit, Lordship, additional affidavit. that he has not applied for selection process.
Heard as per the learned counsel for the petitioner. Also heard MS RB Bora, learned standing counsel, BTC, whereas the respondent number 9 is represented by Sri H. Sharma. Full stop, para. Considering that this writ petition is pending since the year 2016, wherein the necessary pleadings have been exchanged, the same is taken up for disposal at the admission stage. Full stop. Para. The claim of the petitioner, the grievance of the petitioner is with regard to alleged regularization of the services of the respondent number 9, who according to the petitioner is junior to him in service. Full stop. As per the facts projected, the petitioner was inducted as an additional assistant teacher in the Uttar Shekhar ME school in the district of Udalguri by a resolution by the school management committee on 1/5/1995, pursuant to which he had joined the school on 3/5/1995. The petitioner claims that his services were approved by the district elementary education officer, Darang, on 24/5/2000. Full stop. As per the petitioner, the respondent number 9 was appointed in the same school in the year 1998, and therefore much junior to the petitioner. Full stop. Para. According to the petitioner, the services of the respondent number 9 was, however, regularized by an order dated 21/2015, which is the subject matter of challenge. Sri Upadhyay, the learned counsel for the petitioner, submits that admittedly, when the respondent number 9 is much junior to the petitioner, the benefit of regularization of services could not have been given to him. Full stop. Para. On the other hand, MS Boro, the learned standing counsel, BTC, has submitted that the projection made on fact by the petitioner is incorrect, is wholly incorrect, and there is no candid disclosure of all the facts. Full stop. By referring to the affidavit in opposition filed by the BTC, more particularly paragraph 3 thereof, it is submitted that it is not a case of regularization of the services of the respondent number 9 vis-a-vis the case of the petitioner. Full stop. The actual facts were that a selection process was held for regular appointment, in which both the petitioner and the respondent number 9 had applied for,
Petitioner not applied.
in which the petitioner, he said the interview did not appear. Did he apply?
He did not apply as per our.
He did not apply in our. क्या की पुस्तक होते हैं? A selection process. A selection process होता है. For regular, in which the respondent number 9 had participated and the petitioner had chose not to participate. Full stop. Pursuant to the same selection, comma, the respondent number 9 was initially appointed in which school?
In Rajagar ME School.
In Rajagar ME School, which however turned out to be a vacancy,
This school was for Hindi medium.
which however turned out to be a Hindi medium school, and therefore the order dated 21/2015 had to be asked, by which the services of the petition, service of the respondent number 9 was brought back to the parent school. Full stop. Para. Shri H. Sharma, learned counsel for the respondent number 9, has, while endorsing the submission of the BTC, has also submitted that though the petitioner may be though the petitioner may be senior to him in senior to him with regard to the date of joining in the school in question, comma, the same is not at all relevant, as the order dated 21/2015 is not an order of regularization, but an order relating to a regular appointment pursuant to a selection process. Full stop. By referring to the affidavit filed by the respondent number 9, comma, more particularly the averments made in paragraph 8 thereof, comma, Shri Sharma, the learned counsel, has submitted that in the recruitment process, comma, the respondent number 9 was adjudged the first nominee, and accordingly he was initially appointed in the Rajagar school which appeared to have been done inadvertently, as the sage school was a Hindi medium one. Accordingly, comma, the order dated 21/2015 was passed, by which the petitioner, who is the respondent number 9, was appointed in the Uttar Sekhar ME School. Para. After hearing the parties, comma, this court is of the opinion that the challenge made to the order dated 21/2015 is based upon certain grounds which are factually incorrect. Full stop. Our writ court exercising powers under Article 226 of the Constitution of India is a court of equity, wherein the conduct of the petitioner is of paramount importance, which requires a candid disclosure of the facts. Full stop. In the instant case, comma, it appears that the fact of the recruitment process pursuant to which the appointment of the respondent number 9 was made has not been disclosed at all. Be that as it may, comma, even giving benefit of doubt to the petitioner on this aspect, comma, what transpires is that the disclosure made by the contesting respondents have not been denied by the petitioner. Full stop. In any case, comma, what transpires from the records and materials placed before this court is that the appointment of the petition, appointment of respondent number 9 by the order dated 21/2015 is not an order of regularization of service, but an order of fresh appointment pursuant to a recruitment process. In any case, regularization of service of teachers who are appointed in a provincial day school by the SMC is not even permitted by law. Under those facts and circumstances, this court is of the unhesitant opinion that the instant case has been referred on the basis of certain grounds which are neither tenable in law nor on facts. Accordingly, the same stands dismissed.
Lordship, I want to clarify only one thing, Lordship. Initially, Lordship, he was, when respondent number 9 was appointed in Uttar ME School. On his application as his Rajgor ME School, he applied that school is Hindi school, so I may be accommodated to Uttar ME School. So we accommodated, but same memo number, both the appointment letter.
Doesn't matter.
Lordship,
Highly obliged.
deeply.
Well, Lordship has only mentioned the date, that notification, that order number is not mentioned.
No.
According to Mukhtar, it's not.
Both the attempt date. Deeply obliged, Lordship.
Lordship, as per information I have received over telephone from the petitioner, petitioner has retired from service on 1st September 2018,
Okay.
and this accommodation was given on 13 January 2022, Lordship.
So there is no, in 22, what relief can you give to a person who has retired in 18?
Earlier salary may be paid to the petitioner, Lordship. Since 2007, he has not receiving.
Yes,
Here, my lord, probably petitioner illegally appointed, initial appointment is illegal.
and that is okay, but the issue which has been raised is with regard to the payment of salaries.
My lord,
You
here
said that you have appointed her on
in
as a
21,
tutor in 2022,
2018,
and madam, you have retired in 2018.
1st September.
So where is there any scope of appointment in 2022 as tutor?
no, my lord. Already she has retired, my lord. If required, my lord, we'll file a detailed affidavit, my lord.
But that aspect will not come for consideration. We'll be only concentrating on the issue raised regarding the salaries.
My lord. To my instruction, my lord, initial appointment of the petitioner is illegal now.
And that those issues have been decided earlier.
My lord,
Yes, Lordship, here is single bench order is also there, and division bench judgment is also there. And she was regularized, Lordship. Petitioner was regularized.
Okay.
Page number 32, Lordship.
3-2.
32. Petitioner was regularized on 1st July 19.
When were you appointed, madam? Initially?
Appointed on 30/9/1989.
And that was also after a High Court order.
Yes, Lordship. Annexure 2 is her appointment letter. Annexure 2, page number 19. 19.
19.
This is her appointment letter.
Dated
3 October 1989.
3rd of October.
Yes, Lordship.
What is your name?
Aruna Code.
This is of Munin something? And others. Okay, you are also there perhaps. In this petition, you are also a party or what? Munindranath Gohai?
Yes, yes, sir.
This order which you are referring to in contempt 10588, in others you are also there.
Yes.
Corona
sir.
Koch was there.
Yes, sir.
Next page, Annex 3, Malo.
Page
Page
21.
Aruna Kuch, a local resident candidate having been passed by SSA.
Assistant teacher,
Malo.
Yad Hall, Patir Chuk, LP School. Yes, sir.
Against current, this appointment is purely temporary and she may be terminated from service without any prior necessity.
Appointment
They
order.
were there to join her duty. Munindra Gohai. This is an order, this is in case of 1988, my lord. Next is an except for my lord. This civil original petition.
Corona Koch.
Her name is at page 25, Srimati Aruna Koch. In the case of 1988, my lord, here. This honorable court, it is
825. Serial number
5.
internal page 3, my lord.
55, yes.
Serial number 5.
They are all petitioners in this.
Petitioners.
What's the division bench? Oh, at that time, petitions were for division.
Assessment is here, page number 57, Lord.
No, 28. Come to 28 also. Please read this.
It is stated by Sri Pupon that despite of the direction of this court contained in the order passed on 25/4/1988, the respondent are going to take steps in violation of the aforesaid order. Trust and apprehension was expressed by Sri Pupon earlier also on 6/10/1988, when we had stated that no action shall be taken by the respondent. We should be in violation of the order passed by this
Understood.
court. So therefore, do not think it necessary to give further direction.
Now, when you said you retired 2018,
18.
you have the date?
1st September.
Date
1st September
0109.
09.
And the order of tutor?
13/1/2000.
13.
13/1/3.
13/1/2022.
22.
Third. MSD Angana Learned Council for the petitioner. This petition has a checkered history wherein litigations had started from the year 1989. The present issue, which has been initiated by this writ petition instituted in the year 2017, is with regard to release of arrear salaries from the month of August 2007 and also the current salaries which was made at the time of filing of the writ petition. Full stop, para. During the course of the proceedings, this court was apprised by the department, by the council, learned council for the department, that matters of similar nature were taken as a whole and as an alternative, the offer was given to the affected persons to be appointed as tutors, and in accordance with such policy, filed an order dated 13/1/2022, the petitioner was also sought to be appointed as a tutor. Full stop, para. The learned counsel for the petitioner, however, has submitted on instructions that the petitioner has retired on attaining the age of superannuation on 1/9/2018, and therefore the appointment sought to be given as tutor on 13/1/2022 is redundant and will have no meaning. Full stop, para. Though this petition is of the year 2017, the issue involved, namely release of the area salaries, would still be required to be considered. Full stop, para. Under such facts and circumstances, Sri Bora, the learned counsel for the department, pressed for some time to obtain the instruction regarding the further course of action. List for admission immediately after the vacation. You want to date?
Yes, Lordship.
Tell us. We'll have it on 25th of July,
Yes.
Tuesday. Mr. Bora,
Mal.
25th July.
Obviously.
The Andana.
See, we have received the affidavit filed by the respondent authority, except the item number 25, that is the application number 7004, madam. Now, my humble to your lordship, you may be allowed to grant some time to make our response. Since all the.
They have filed an affidavit.
They have already filed except the item number 25, that is the application 7004. Others file we have received.
And the affidavit are filed in the others will also cover the left out WPC, no?
No, madam. No.
Issues are separate over.
Issue, cause of action and relief sufferer same, my lord. They are filing in all our cases separately, madam.
Understood, but will
Some instruction regarding this case, my lord. They are as per earlier.
will the affidavit filed in the other cases cover this case also?
Cover, my lord.
It will cover. Then we may not insist upon filing another, but it will give you time to have the response.
My lord.
In this series of cases, dear sir, series of cases, affidavit in opposition has been filed by the department. In all the cases except WPC 7004 2017. Full stop. Sri Bora, regarded. Pen of he further clarifies that the affidavit filed in the other cases would also cover WPC 7004 2017, and the issues are similar. Full stop. Sri M.U. Ahmed, learned counsel for the petitioner, however, submit that some time may be granted to him to enable seeking of instruction on the affidavit filed by the department. Full stop. List immediately after the summer vacation.
Lordship convenience, date may be fixed, my lord.
You tell us. You tell us.
Maybe in the month of July, last part of.
We'll have it on 26th.
27th, my lord.
20, no, not on Thursday. 26th or 28th.
The 22nd,
22nd is a Saturday.
except 20 and 26 was very different. 28 maybe like.
28th.
my lord.
That's it. 28th, 7.
Oblige.
Okay. Mazumdar?
My lord, in this case, lordship, government has filed their affidavit, lordship. I may be allowed to file rejoinder, lordship. And also respondent number
Okay.
7. lordship.
3 K.A. Mazumdar, learned counsel for the petitioner, submit that the
Director,
government, that the department, that the affidavit in opposition by the respondent number 3, within bracket, director,
director,
has been filed recently on 16/6/2023, to which he would like to file a rejoinder.
lordship. And also,
Have you filed affidavit against Mr. Khan? You are 7. Who is 7?
7 lordship private, he also filed his affidavit, lordship. In that
You are
also
not
I-
for 7, private respondent number 7. Who is there? 7, who is there?
7 MH Raj would be a lordship. He has filed lordship affidavit, but I could not file the rejoinder.
Now, where is he?
On that also, I will also file that.
Name shown or not?
Name shown, lordship.
Khan, who, you are for whom? That we know. Who is this for? Would you like to file anything? Not required.
I will file rejoinder also in respondent number 7 also.
3. Mazumdar also craves leave to file rejoinder against the affidavit of the respondent number 7, which, however, was filed in the year 2018. For Kapara.
I will
3
file
M. Khan, Senate Council has appeared for respondent number 6 and submits that affidavit may not be required to be filed by him. Full stop. Anyone from the department? The Pika Bora, Senate Council has elementary.
No, it is elementary.
Senate Council has appeared for
That is secondary law.
you Sharma, not the PK Bora. Senate Council, Standing Council has appeared for the department. Full stop. Para. List after the summer vacation, by which time the affidavit in reply as referred above may be filed. You file immediately then.
Lordship, they,
You file it first.
lordship. March applies, lordship.
In this matter, my lord, I am bit handicapped, my lord. The file I have, my lord, misplaced it. So I have, my lord, got a copy of the writ petition. My lord, got a, my lord, Xerox copy of the affidavit filed by the respondent.
Okay, we'll done sometime.
Yeah.
3B Gogoi, learned counsel for the petitioner, praised for some time due to some personal inconvenience. Full stop. List immediately after the summer vacation.
My lord. Oblige.
3 U Sharma, learned standing counsel of the department is present.
Oblige.
Yes, what is this?
Lordship. But matter pertains to non-payment of arrears.
Have you filed the reply affidavit?
Your Lordship, case may be proceeded with. We would like to argue.
You would not like to file a reply. It's 19 matter. If you insist, we can take it up for final disposal also now.
Yes, sir.
Mr. Bora,
My lord.
what is the matter about?
It is non-payment of arrear salary
You were working as what?
as a teacher. Your Honor.
In which school?
Eh,
Ramugao LP School, Sisagar.
In Srinagar, you are working as as an assistant teacher in an LP school.
Yes, Your Honor.
Since when?
Till 2018, Your Honor.
No, since when?
Since 1995, Your Honor.
And 12 to 18, you have not got your salaries.
Yes, Your Honor.
Yes, what illegal teachers or what?
By illegal teacher. Petitioner, my lord, here we have filed in detailed affidavit, my lord. The very appointment of the petitioner is illegal, my lord.
Have you been served with the affidavit in opposition copy?
Yes, Your Honor. We have
Have you-
received the gratuity and insurance. Group insurance and gratuity we have already received, Your Honor.
But here, what has been stated in the affidavit in opposition?
But here petitioner was
You were appointed in a non-existing post. Have you seen the statements in paragraph 5? Page 3, internal page 3 of the affidavit in opposition.
Your Honor. Your Honor, may kindly turn to para 13 of their affidavit.
1-3.
Yes.
What is there? All those
Uh,
different-
Second portion, last portion, Your Honor. However, the decision of the cabinet was prospective in nature. Petitioner had attained the age of superannuation 2018 prior to the approval of the cabinet. In view of such peculiar circumstances, petitioner could not be accommodated as teacher, tutor as the case may be. So my services was utilized, but my salary has not been paid. Area salary has not been paid. That is, Your Honor. We are not asking for anything, Your Honor, just the area salary for our services rendered.
Now, see, you have taken a policy decision
my lord.
that considering the nature of their entry into the service at 1989-91, that it was not against the existing post or there were inherent defects in the recruitment process. You had taken a very holistic view that whatever has happened, we will give them appointment as tutor.
Tutor.
So it is giving some kind of always benefit to the incumbent. Now here we have a person, even in the last case,
My lord, yes.
who had retired
In the
even
year
before you could take the decision and policy as a matter of policy to offer them the appointment as tutor.
my lord,
Now, how will you deal with this kind of case? Exactly what has happened in
my lord.
the earlier
Yes,
case
yes.
where the Dhemaji
Yes.
matter was there.
My lord. Regarding this, I'll take a second, but as per the affidavit, my lord, the appointment of the petitioner was treated as illegal.
No, that is illegal, but you are not disputing that the petitioner had discharged her duties
My lord, right.
in that period. If you have disputed that, yes, regarding her statement that he had discharged, you are disputing that.
Right.
That matter is different. Other, you are admitting that that period she had worked.
Right.
Maybe her initial appointment was not a regular appointment,
My lord,
but you have not
This-
cancelled,
my lord,
and there has been intervention of this court.
Right.
And if now you have taken a policy decision to give recognition to whatever she has done,
Right.
and now work prospectively as a tutor, which benefits she will not be able to get because she is already superannuated. And how do you deal it? When is the other case?
on 25th, 25th July. 25th.
Your G. Regma,
Yes, Your Honor.
heard to G. Regma learned counsel for the petitioner, who submits that reply affidavit may not be required. Who also heard
Item 21.
3. P.K. Bora, the learned training counsel of the department. this case pertains to a claim for release of area salaries.
Retirement benefit,
Your retirement benefit you have got,
no,
and part of retirement benefit. Retirement benefit on the strength of serving as an assistant teacher in which school?
Ramugao,
In the Ramugao LP school. In the district of Nazira, in the district of Sivasagar. Full stop. The Learned Council has submitted that an issue on the legality of her appointment had arisen, which led to a number of litigation. And finally, a policy has been taken by the government to offer appointment of all such incumbents as tutors. However, before such policy decision was taken, to which the petitioner could get benefit, he had already attained the age of subordination and retired in the year 2018. And this petition was filed for arrears salaries from May 2012 to May 2012 till her date of her retirement. Retirement along with part of her retirement benefit. This court has noticed that similar issues are also pending in other petitions, including WPC 3355. What was that order?
3355 of 2007.
Item number?
Item number 21. Corona code.
Three, including WPC 3355 2007, which has been fixed on 25th. 25 July. List this case along with WPC on 25th July.
Obliged.
These two methods may be taken up after that.
Some difficulty today. Mr. Das will be appearing.
Mr. Rajesh,
We'll have it after the vacation. Madam, you're appearing for whom?
Assam Agriculture.
On behalf of Mr. Goswami?
Yes.
On the prayer made on behalf of the petitioner. Matter change adjourned to be listed after the summer vacation. Yes.
Obliged.
The last provision here I have taken time to bring inspection, but I have not received yet. Item 41.
Madam का नाम is present for is present for the Assam for yes. What is this?
Matter pertains non-appointment of the method after being qualified teacher method. Basically agreed by the neither 5 is 42.
If you filed affidavit.
No, my
No, my lord. My lord. I need some more time, my lord. I have yet to receive.
19 matter.
19 matter.
Last time we had last occasion given to time of 2 weeks. Further time of 2 weeks is granted to Sri P.K. Bora to file the affidavit in opposition. Full stop. Please immediately after the summer vacation.
Obliged.
Yes, next.
Obliged. May I pray for a date?
Let him file affidavit sir, immediately.
File it. Yes, obliged.
We may not be inclined to give further time, Mr. Pura. Utilize this time. Yes, what is this?
My lord, we were informed by the learned counsel for the respondent that he would be seeking adjournment.
Respondent, who is
BTC.
BTC? Yes, BTC, madam. Mr. Nayak. BTC has filed affidavit otherwise.
Yes.
Have you filed any rejoinder?
No, ma'am.
Would you like to file a rejoinder?
My lord.
Additional affidavit by respondent for 4. I think you filed rejoinder. But let's see. Yes, you have filed rejoinder against R4. Aren't you aware? Your Sahid Afridi.
No, my lord. S.H. Mohammed.
Sahid Afridi is your colleague.
Yes.
You have filed your reply. Yes, madam. A prayer for adjournment has been sought by MSD Boro, S Boro, Senate Council appearing on instruction of MSRB Boro, Senate Standing Council PTC. Please immediately after the summer vacation.
UN lordship for instruction, lordship, we could not protect our client.
Instructions, what instructions? 16 matter, madam.
I could not contact our client.
What is the matter about? Yes, madam, you are appearing for?
Elementary education.
Have you filed your affidavit? No.
Lordship, I will file after vacation, lordship.
Hmm?
After vacation, lordship.
Matter is of 16.
Lordship.
16 matter, we are not adjourning. Okay, as a specific term does not come up. So this matter is of the year 2016, it appears that after rule was issued on 4/5/2016, it was listed only once on 8/1/2021. It further appears that neither any affidavit in opposition, neither any affidavit that is filed by the respondent, nor any instruction of the input of Sarah. The learned counsel for the petition has also prayed for some accommodation. So as a special circumstance, comma, the matter is adjourned to be called immediately after the vacation on summer vacation on 2027-2023, on which date, comma, this court may not be inclined to further adjourn the matter. We have a meeting authorized early.
Name of the respondent number 4. I'm for respondent number 8.
It is for the department. Secondary education. It is submitted on behalf of the petitioner that an IA is required to be filed for striking of the name of a particular respondent. One respondent,
One respondent. Respondent number 4.
namely the respondent number 4. Let this matter be listed immediately after the summer holidays, by which time such IA may be filed.
If the first.
Please, your lordship.
Yes.
In this case, lordship, petitioner is working as a subject teacher in English at Sanaram SSC School, Tinsukia. Previously, he was working Bordubi SSC School, lordship. When she transferred from Bordubi SSC School to Tinsukia Sanaram School, his salary from 110,2000 to 28 to 2001 has not been paid, lordship. In this regard, government has already filed the affidavit, and in the affidavit, government also admitted secondary education has filed the affidavit, lordship. In para 6 of the affidavit filed by the secondary education, they have forwarded the bill.
Yes, what is your stand? Finance department.
There's a slight clarification, my lord. The matter pertains to arrear salary, my lord. Here, a statement was made. Lordship will peruse order dated 10/4/23, my lord.
10/4.
Yes, lordship.
Yes.
The second last para, my lord. If the disbursement of the amount of rupees so and so as claimed by the petitioner and so, which is mentioned in para 6 of the affidavit filed by the secondary education department, has not been made only for the non-production of non-drawal certificate, the authorities in the secondary education department shall issue the direction to the concerned DDO of the petitioner to forthwith issue a non-drawal certificate and to deliver it to the treasury officer, my lord. Now, whether they have issued the DDO, my lord, the main issue is whether the DDO has been given to the, the non-drawal certificate has to.
Yes, has it been given?
In this matter, I have received the instruction from Deputy Director of Secondary Education to the Inspector of School. It is instruction of 12 June 2023. May I read, my lord? With a reference to the government letter on subject cited above, I am directed to request you kindly to submit the non-royal certificate from the concerned DDO with a counter signature of concerned treasury officer for release arrear salary in respect of Srimoti Juri Bora Pukon, subject teacher of Seniram SS School under Tinsukia district, in compliance of the Honorable High Court order dated 25 to 2022 in WBC so and so for taking further course of action.
When was the instructions given?
It is 12 June, my lord. It is sent to the inspector of school. They are after non-response.
The instruction is silent on the part whether the non-drawn certificate has been sent to the treasury officer or not, my lord. This is the interdepartment communication between the director of education and the inspector of school. That is the issue, my lord.
But why should the petitioner be made to suffer from 2018? Just Sharma, you asked the officials to work to do this, settle this matter expeditiously. Otherwise, we'll have to take the matter in a different perspective. From 18 to 23, matter is pending for a interdepartmental communication.
My lord, one instruction also there. It is pay for 2023. Here in the last part, it is stated that, however, with the closure of financial year 2020 to 2023, the date for sanction of area salary is now over. The department shall process the proposal in the new financial year 2023-2024 once all the relevant documents are received.
23-24 financial year has started.
Yes, right.
The financial year started from 1st of April. We are in June.
Already process is going on, man.
So we want a final
Yes.
third treaty the learned concept for the petitioner to submit that in spite of the clear direction of this court dated 10/4/2023 till now, the arrears salaries have not been paid. On the other hand, Sri U. Sharma, the learned training council, secondary education department, submits that as per written instructions dated 12/6/2023, the office of the directorate has written to the inspector of schools, Sibsagar district circle.
Yes.
For
Tinsukia, my lord.
for the inspector of schools, Tinsukia, for taking steps for issue of non-royal certificate in consultation with the concerned treasury officer. The matter, this matter is pending since the year 2018, and it appears that only for certain interdepartmental, it appears that only because of lack of coordination between the departments, the petitioner, the entitlement of the petitioner has not been released to her. Under those facts and circumstances, a last opportunity is granted to all the respondents to ensure that the process for release of the entitlement, which otherwise has been admitted, which otherwise is admitted, be completed within a period of a month from today. List on 20,
2 months,
not 2 months, 18 matters.
Okay.
List on 3 and 6. List on 2nd of August 2023, on which date instructions regarding finalization and disbursement of the amount in question is to be placed before this court.
Morning.
Hmm?
PP Bora,
46?
46.
Okay, he had short time, I think.
Yes, sir.
You were not there, so we did not.
I was there, but NCT.
NCP. Now, NCT is there or not? A prayer for adjournment has been made on behalf of the petitioner. Also heard. 3. S. Bora, Standing Council BTC. Elementary and CPK Bora, Standing Council Elementary Education Department. So, para, please, after the summer vacation. Five zero. Yes, what is this?
My lord, it's in 2017 order, my lord.
Quantum.
Relate non-payment of area salary.
What is this IA?
My lord, personal appearances, my lord.
IA, we have to pass orders. What is this? IA for?
I have a personal appearance. Opponent has filed. I have
Exempting for personal appearance. Who is the Anne Fukan? Where is Miss Anne Fukan? Anne Fukan has passed she has filed an application for dispensing personal appearance and for striking off. What is the stage of the contempt petition?
competition. My lord, they have not filed affidavit till date.
No affidavit filed.
Only from page 16, my lord.
None of them have filed affidavit. Yes, madam.
The state concerned for filing affidavit.
In the contempt case,
Yes, madam.
case of 2018.
Order passed on 2017.
None of the respondents have filed affidavit.
No, my lord, they have not filed any affidavit, my lord. They have not also prepared any review petition, my lord.
Somebody has filed affidavit. Return Sekhi has filed affidavit. Who else? He has filed 2 affidavits. Where is Mr. Mazumdar?
Lord, he left the court with some personal difficulties. Sir.
When is he implemented? He responded he is appearing for.
I don't have any idea regarding the contempt.
We'll have it. Purohit Bandhani. No, Purohit. We'll have it day after tomorrow.
Yes, sir.
Day after. You are D. Bhuya.
My lord.
Arch D. Bhuya learned concept for the petition. Para. Do an IA has been filed to strike off. By respond number 1 to strike off his name from us. There is none to press the IA. Put the para. In the interest of justice, list again on Wednesday next. Purohit.
Obliged.
Please inform Anne Fukan and also our Mazumdar to be there day after tomorrow. Yes.
In this cases, I appear for respondent number 9, 11, and 16. We have filed our affidavit. The issue is because
681 persons should be released their mother teachers salary, area
Just a minute,
salary.
just a minute. As per for
That's one over 9, 11 and 16.
9, 11, 16. Affidavit file.
Affidavit file.
File affidavit.
Well, essentially, it is respondent number 9 who has filed an affidavit, whose, views will be relevant.
9 is who?
9 is the director,
Director of
PTC,
PTC,
education.
my lord, school education, PTC.
or Director of Education PTC.
Stand of 9, 11 and 16 are same. Okay, I'm referring to 14. 1-4.
14.
Yes.
B. Bora. Anyone else?
For 12.
Name.
Name.
You could. On behalf of PC Bora.
Your name.
You could.
You Ghosh. R. 12.
12.
Anyone else? All right. Okay. All of you have filed affidavit.
My lord will kindly have the affidavit filed by respondent number 9. That is page number 125.
One 25.
It starts at 125.
Part of the affidavit of which?
Affidavit. Additional affidavit. And if your lordships may kindly come to 129, paragraph 6.
25.
Page 129, paragraph 6.
This is an order of 18-1.
No, my lord.
Now, is it annexure 1?
No, my lord. I am referring to para 6 of that affidavit. Additional affidavit.
Running page number is 129.
120.
129.
29.
You are referring to?
Para 6, my lord. That accordingly BTC has released.
Is it a court's order? No.
No, my lord. It's a part of the additional affidavit filed by respondent number 9 on 26/23.
By Ruby Shankar Borgar.
No,
No.
no.
It is JP Burma.
Jagadish Prasad Brahma.
Tell us the destination will not help. By the response number
9, my lord. Additional affidavit dated 26/23.
9. 9 has filed an affidavit on 29/11/22 there. 9 F20. Yes. That's at part 96.
Has your lordship got it?
Just 196. That's correct. The new pagination is 196.
Actually, my lord, in this case, so many pleadings has been filed.
There is
Maybe-
also 125 written, but it will be 196. Nonetheless, yes.
Yes. Please
Yes.
come to paragraph 6 of that affidavit.
petition document. 20th of 2023. Page, paragraph 6.
Para 6, internal page
Yes,
5.
yes, yes. That accordingly.
That accordingly, PTC has released an amount of rupees 1.17 crore by sanction order dated 23rd of March 23 for payment to 314 number of mother teachers. Answering deponent as Director Education issued direction for payment of 304 numbers out of 314 as 10 number of mother teachers could not be located. Again, the answering deponent as Director Education PTC has submitted requirement of fund amounting to 1.12 crore white dated so and so for payment to 303 number of mother teachers, and the same was sanctioned and released to him white order dated 29/5/2003. Thus, BTC has released payment to 607 number of mother teachers out of 681 till 29/5/23.
Yes.
Further, it is informed that name of one mother teacher is found recorded twice in the list of 681 number of mother teachers as provided by the petitioner. Thus, the actual number of mother teacher has come down to 680. Let us accept 680, my lord. Then my lord will kindly come to page number paragraph 9. There was some dispute regarding 75 numbers, which they have clarified, my lord. That the answering deponent begs to state that in the meanwhile, the authorities in PTC could trace out 65 number out of 73 number of mother teachers indicated in the advertisement. That on 14/6/20.
You're reading?
Para 9, madam.
9. Yes.
That the answering deponent begs to state that in the meanwhile, the authorities and PTC could trace out 65 number out of 73 number of mother teachers indicated in the advertisement. That on 14/6/2003, Director of Education by letter dated 14/6/23 submitted further requirement of fund amounting to 25 lakhs and 30,000 for payment of outstanding liability to the liability of arrears salary in respect of 65 number of mother teachers. Therefore, their stand is, my lord, they have sanctioned for in all 672. There are some dispute regarding it out of 680. But our information is, my lord, the list of 65 which has been indicated, they are our members, but the regarding rest we have no information. Because in the additional affidavit filed by us, my lord, affidavit in reply, way back on 7/11/22, we have given that list of 681. So out of that, only 65 are ours. The rest, my lord, they will have to say that out of this list, whom they have paid. Because our members are scattered in all throughout the PTC area. We cannot go and find out, my lord. So what I will respectfully submit, my lord.
What about the initial statement that for initially they had released 1 crore 17 lakh.
Yes.
Then another for 1 crore 12 lakh, and 607 numbers have been paid.
They say.
You say that they are not part of yours.
No, we have no information. So because our list is before them, because it is apparent that they have proceeded on the list furnished by us. So let them show by the next day out of the 680 whom they have paid.
No,
we haven't received, my lord. My lord will kindly appreciate these people were, my lord, discharged long back. All of them may not be having bank account. They want that no bank account is required. Somebody are maybe in the process of opening bank account.
No, those parts we will definitely consider their status. But isn't that your responsibility to tell before this court, or maybe appraise the other side, that you are an association, aren't you? You have 680 members, 81 members.
680.
80 members. Out of them, you say
65 the names, my lord, which they have given in the affidavit, that belongs to they are our members. For them, fund has been asked for 25 lakh. That they have not paid. That they may be in the process of paying.
no, but the assertive statement which they have made,
Yes.
that 607 has been paid. Are you disputing that you have? Because I think you the
My lord,
information has
can
to.
do one thing, lord, you can have it after the reopening, my lord.
That is
In the
it.
meantime, we will take note.
Because contempt jurisdiction, as you
Yes,
know,
right.
if we find that it is substantial compliance, but if you are seriously disputing that none of you have been paid, this is something on paper, then that's a different matter. But Mr. Sharma, I think you can
Yes, yes.
get the information. If we
Lord,
find it
since time
substantial,
permission, can I?
yeah, sure. But we'll be only inclined at whether
Yes.
substantial compliance is there. And these matters stated by the director on affidavit, there is nothing to disbelieve this.
Only thing is that they have only said that the PTC authority has sanctioned to the director, but director has not released to the money.
No, that is pertaining to 65. That is only pertaining to 65. But they have already made a statement that 607 have been paid.
No, see, for 607, they released the amount, Lord.
That is release means what?
Our statement is that Lordship, in
Our-
total, we have a list of 681. One name appeared twice, so exact number is 680.
Exactly.
Out of 680, Lordship, only 8 left, Lordship, till now. Others have been paid, Lordship. That is our stand, Lordship. If they are disputing that, Lordship, they should file an affidavit and bring that to this before this honorable court, Lord.
Mr. Sharma, see, statement made on affidavit on this, there is nothing to dispute or disbelieve rather. But if you are saying that no, these statements are only on paper, we have not received, then the responsibility will be yours to file an affidavit and say that out of 680, who of you have not received the payment? Once they have said on affidavit,
But the main problem we have facing, Lordship, list is for which matter is the sanction has been made. That
no,
list
that
is
problem
not
is
with
yours,
That
Mr.
is
Sharma. You cannot pass on the problem to the court or the other side. You are the petitioner. If you don't know who are your members, can we help you?
But my petitioner assistant, Lordship, approached the authorities to furnish the list, Lordship.
Why? You don't know your members. They'll give you the list. You're the
I
association.
will file one reply.
What is an association? Association is consisting of members. You do not know your members. How can this contempt be maintainable then?
They have those 8 members are not found. We have inquired, but all 8 members are alive, Lordship. They are also there. But for these 8 members, they have not provided sanction, Lordship.
See, we will not be bothered with 1, 2, 5, 8. We will be only concerned with a substantial compliance.
Lord.
In a numbers of 680, if 2, 3 members are not found, we will not have a contempt. We'll see there how have they have treated the court's order.
But by next year,
If
I will
it is
file one reply, Lord.
complied substantially, then we may not proceed against them. Our anxiety is only whether the order has been deliberately flouted, violated, or have efforts been taken to comply with the orders. They have made a positive emphatic statement on affidavit. 607 have been paid. Mr. Nayak says that only 8 have been left out in the meantime. Others have also been paid.
In fact, my lord, 672 sanctions have been done. We are getting it. 8 numbers of persons, we have not been able to locate it. If they come with your papers, we will issue that. That also will be paid.
Third, Sri K. N. Chaudhary, London City Council, for the petitioners. The petitioner number 1 is an association of mother teachers of schools in the BTAD. And this present case pertains to an order of this court whereby payment of salaries were directed. Also heard this to below. Mr. Dhari is also appearing, I think. Anyone left out at that time?
Not for 7 and 17 lot.
Huh?
Yes, sir, 7 and 7.
Where is he?
Property is on Lake in Accept.
If he's not there, somebody else has to be there. Anyone for him?
Respondent number 15, my lord. Direct.
PK Bora here for 2.
So, my lord, my name is recorded. I am appearing on behalf of
2 and 15.
Fine.
Nayak, if you appear on behalf of him, you can.
Yes, Lord, I can.
Then Nayak for 14 and
47, 14 and 7.
7,
14 and
14 and 17. Okay. Para. An additional affidavit has been filed with respondent number 9 on 26. Sorry, report is filed. So it has appeared. All the efforts that respondents have filed their respective affidavits. An additional affidavit has been filed with respondent number 9 on 26/20/23, in which, it has been stated that the BTC has released an amount of rupees 1
total is 2
1, 17, 74, 859 for payment to 314 numbers of mother teachers. Another amount, paragraph 6, that is 200. Like Laura ji. Green flag, for Lois, for 205. Another amount of rupees 1, 12, 10, 928 has been released for 65 numbers. 303.
Paragraph number 6 itself, subparagraph 2. For 65, we will have at least 25 numbers. In the second paragraph.
Another amount of rupees 25, 30, 282 has been released for payment in respect of 65 numbers of such teachers. There were certain teachers which were not traced out, and there has also been anomalies in the list as it contains, as there are duplicates in one, there is duplication in one name. This court has been informed that those 681 numbers of mother teachers were said to be involved, actually there is 680 as one name was repeated, out of which 672
amount
have already been, the amount for 672 such teachers have already been released.
And this is so, my lord, just down to paragraph number 10. Total amount for all these 672 is 2,51,51,092.
093. In total, this amount, an amount of rupees so has been released for 672 numbers of mother teachers.
8 has not been till now, it cannot be traced out. If they come with the papers, we will
It is, this court has further been, it is further submitted on behalf of the respondent that the remaining 8 number of mother teachers could not be traced out, and therefore not being able to be paid. And the said amount would also be paid as and when such mother teacher
As stated in
approaches
paragraph number
the authorities with proper document. Full stop. Para. The senior counsel for the petitioner accordingly please for some time to obtain complete information on the 10 of the respondents. Full stop. Para. There appears to be substantial compliance. No. From the statements made in the affidavit and the submission made by the learned counsel for the respondents, it appears that there is substantial compliance with the order of this court in question. Para. Be that as it may, not and in the interest of justice, let this matter be called again on 24th of July 2023 to enable the learned counsel for the petitioners to obtain necessary instructions. Full stop. Take on to comply. Senior counsel. Change to the petitioner. Part two. Part two. Son amendment. Part two. File. Okay. 2009 matter আছে না? মাথা না থাকলে কি হবে? তাও ফাইল আছে লিস্ট আছে লিস্ট আছে না? হ্যাঁ? 15 number karma sir. Selection permanent contractual dispensation. None appears for the petitioner on call, whereas the secondary education department is represented by Ms. S. Terangpi. H. Terangpi. Full stop. The petitioner claims to have been appointed as a contractual teacher by virtue of a recruitment by virtue of a selection process in which the petitioner claims to have secured the second position. Full stop. the action of the respondent in engaging the nominee in the first position was the subject matter of challenge in WPC 2070-2011 instituted by the present petitioner, in which this court had passed an order dated 27/7/2012 interfering with such selection. Thereafter, appointed নহয়, claims to be appointed, ভুল হয়েছে। claims to be claims to have participated in a selection process conducted for additional teacher on contractual basis in the BAS Madrasa Higher Secondary School for the post of social science. Have to take an answer, huh? That's what after as no consideration was made, comma, the petitioner filed a second writ petition WPC 2721/2013 in which with a direction to appoint him in place of the first nominee. The aforesaid petition was, however, withdrawn with a liberty full stop. Accordingly, the present writ petition has been filed. Full stop. MS Terang P. the learned training council, secondary education department, however, submit that the recruitment process was admittedly for a contractual teacher for 11 months, which has expired long time back. He further submits that the select list itself has spent its vote, and after more than a decade, comma, such relief cannot be granted. The relief claim does not appear to be such which can be considered after 13 years of the selection process. However, comma, in absence of the learned counsel for the petition, rather than passing any orders on the marriage, comma, this court is of the opinion that the petition may be dismissed or not. Accordingly, the petition is dismissed for want of protection. Put the request for the under the effort setback it also appears that there is no life for the vaccine. There is that's the period. Any other thing? Other the Yes, what is this? This is BTC for the period 97 to 2012.
They are paying for areas separate.
97 to 2012.
12. Here, BTC also filed an affidavit.
I don't know. Tomorrow, if they did not come, we'll listen for report. I'll Tuesday, new method. Motion law, mungkin motion article itu boleh.
Actually, in the post title, they are specifically to
Huh?
here, my lord.
What is it?
Base process. They are in earlier process, they are specifically shown that honorable court will
Peter, Peter. Fine.
Yep, yeah.
Itu nine. Don't get here. Please do. Adik. Lah, go to Namaro. Itu mari kita ni jadi apa? Mari kita beli kita. Kita kahit. I will not pass that order in the first
my lord,
place.
my lord. My lord, that may be the reason that is why advocate cannot.
Okay. It's no. We are even if it's a motion we could have taken, but that indication is not given,
My
which
lord.
you have pointed out.
Otherwise, this in the top, my lord, there is an indication, but
But,
specifically,
Not paper. Pura paper. Mari, Mari. It was a paper. Paper. It was separated to the board. Selected to the paper. Okay, I have to order.